Representative Juvenile Justice Committee, and I'm going to call this meeting to order. We have an agenda today. I think it was on your desk in the chamber. First on the agenda would be adoption of Juvenile Justice Committee rules. In your folder, there should be on the left side, if you're looking at it and got it open, should be the Juvenile Justice Committee rules that I am proposing for this committee. If you've had the opportunity to review these rules, do I hear a motion?
Motion to adopt, Mr. Chairman.
Any objections? Rules are adopted without objection. By acclamation. And by acclamation. Also, so that takes care of that. And the second item on the agenda is House Bill 52 by Representative Quick, Caldwell, Jones, Oliver, and Weldon. Representative Quick, could you present the bill, please?
Thank you, Mr. Chairman. I bring to the committee for your favorable consideration House Bill 52, and just a little bit of background on the bill. In child custody cases, at present, it is possible that the trial judge requires not just, let's say, a final judgment and decree, which involves custody. There could also be a detailed agreement, and this statute requires, in the minds of many Superior Court judge, an additional order be entered called a parenting plan. So just background on this code section, 1991, when it was enacted, after it was enacted, the Uniform Superior Court rules were also amended, and the parenting plan separate order in the Uniform Superior Court rules is an 8-page document. I only had time to print out a few of those, but they're circulating around, so if you have read yours, if you could just pass it on down to your neighbor who might not be familiar with these documents. All the House Bill 52 does is it makes clear in subsection A of the code section that the trial judge has the discretion to not require the entry of a separate, a duplicative order, an additional parenting plan. In other words, the trial judge could say, we have 2 lawyers in this case and we have a 30-page settlement agreement that covers all these things. I'm not going to require another piece of paper be generated in order to resolve this matter. If it's a pro se litigant, the judge could say the pro se litigant has otherwise complied and only requires 1 order, or if the trial judge, him or herself, has conducted the hearing, then instead of doing an additional order or having their staff attorney have to do an additional order, they can include the salient portions of what should be in the parenting plan and what should be in a custody order in the 1 order of the court. And that is all the bill does, Mr. Chairman. I would note that although it's not contained in the bill draft that you have, if you look at 1991 in the code, the next subsection B says unless otherwise ordered by the judge. So I think this was simply an oversight when it was enacted, but some Superior Court judges have taken the position that shall means shall, and perhaps rightfully so, and required these duplicative efforts, which frankly can create confusion and some discrepancy between the parenting plan, which might be drafted in a hurry trying to get folks divorced and get the case over, whereas the settlement agreement is usually a much more detailed and a well thought out document. So that's what the bill does, and I'll be happy to entertain any questions of the chair or committee members might have about the bill.
I have one question, just for my own personal clarification. Once there's a provision in a, say, settlement agreement that incorporates all the things that a parenting plan would or is required to incorporate, would that be, does that just going to change that at all? Do you have to have if you have a separation agreement and it's filed with the court, along with the complaint. Would this modify that at all?
No, sir.
Okay.
In fact, this would eliminate the judge feeling like him or her has to require you to do a separate order that then, as you know, because I think you do this kind of work, as you know, you have to get your client to sign again, to get to initial again, and it holds up the process of actually getting the case finalized. This would eliminate the shall,
Right.
make it a may.
Thank you. I have one. Let's see. Representative Mary Margaret.
I apologize for being late, Mr. Chairman.
Oh, no problem.
Do the Council Superior Court judges have a position on this? You may have said in the beginning, but I didn't. Okay. Do you have a position, just you personally, on whether the child support addendum order is duplicative of a settlement agreement or not?
Well, it wouldn't necessarily be duplicative of a settlement agreement unless the requisite findings were contained in the settlement agreement. So for those jurisdictions, I believe the jurisdictions that require the child support addendum order do so by local rule or standing order, I should say, as opposed to anything in the statutes.
Representative Coomer.
Thank you, Mr. Chairman. Representative Quick, just so I understand, essentially if your bill passes, the only thing that would change for a practicing lawyer on the ground is they can just go back to the old process of referring to the agreement in the final order and have it incorporated that way. Is that in a nutshell what's going to change here?
That's correct. In the discretion of the Superior Court judge, who could still require the entry of a separate parenting plan and certainly can still require those other components of 1991 to be contained within your settlement agreement. It's not going to eliminate the supervision of the trial judge, but it eliminates unnecessary duplication of paperwork if the trial judge doesn't think it's necessary in your case.
Thank you.
Any other questions? Before we move on this bill, I want to recognize a distinguished member of the judiciary, Judge Sam Osborne. If you wouldn't mind standing, Judge, and let us recognize you. We certainly appreciate you being here and being on top of these. And Judge, if I could just pose a question from the chair, you're in support of this this bill?
The Council Superior Court judge did vote to support the bill. I won't go into it in further detail. She's done a real good job of it, but I think we are in support.
Thank you very much. Thank you for being here, Judge. Okay, the chair will call the question.
Move to pass.
Second.
All right. All right. Any objection? All right. All those in favor of the bill indicate by saying aye.
Aye.
All opposed, no. Unanimous. All right. This bill will move ahead. Yes. Thank you very much, Representative Quick. Let's move on to rules. Any other business before the committee? Okay, for any of those who are not aware, we came in, the rules were voted on and confirmed, and they're in a copy of the rules are in your folder. That was taken care of, and then we took up House Bill 52, which was passed unanimously. Being no other business, meeting is adjourned.
Mr. Chairman, have you said you spoke to me?
I hadn't yet. Not yet. Thank you very much, Representative Quick.
Do you have a standing